hey, we're talking about whether or not your spouse, your soon-to-be ex, can take your retirement. And the question depends on several things. How long have you been married? Is that the only significant asset acquired during the marriage? Was any part of that acquired prior to the marriage? And then there are going to be other factors like whether or not the spouse, your soon-to-be ex, has their own retirement account or own investment accounts that they either brought into the marriage or that were created or increased in value during the marriage that they may want to protect in exchange for leaving your retirement or future accounts alone. So just a couple of big bright line rules. Anything that you had before the marriage, if you had $10,000 or $20,000 or more, for example, in a retirement account, let's say you were a school teacher, let's say you were a first responder, let's say you worked for a state or federal agency, and you were already vested before the marriage, anything that you owned in a retirement account before the marriage is not going to be dividable. Same goes for your spouse. Anything that they brought into the marriage that was an inheritance or an account, a retirement benefit of some kind that they brought into the marriage, you won't have a claim to either. Now, the gains and increases during the time of the marriage, those can be significant, and especially when the marriages are long. And so the question then becomes, can you or will you be forced to divide those and then thereby lose the benefit of some of them or half of them or whatever that is? And the answer is often yes. In a long marriage, if that's the most significant asset, usually in a long marriage, the house, the homestead, and the retirement accounts are the biggest assets. The thing that a family law attorney will always try to do is figure out what the biggest asset is and divide just the one thing. Instead of dividing three things in half, just divide the one thing. And if there needs to be a bigger share of that, such that you can protect your retirement account, which your future self will need and thank you for, then that will be the goal. And you'll have opportunities to compromise on things like that. And I think that's especially important for anybody who is retired from the state of Texas, especially because those workers and those retirement accounts, example, any state or county or school district retirement account, those employees are not entitled to Social Security. So it's imperative to try to protect those retirement accounts from division so that you can have the full benefit of that retirement account. You don't need to go back to work. Or even if you don't go back to work, you won't have a diminished retirement because you're not eligible for Social Security because you were a state agent for so many years. So it is an answer that has a lot of nuances to it. The general rule is yes, if you were married a long time, yes, if the account was created or grew of significant value during the marriage, which means it's community property or some part of it is community property. And then there's going to be the other compromises that you can try to make by dividing other potentially bigger assets or giving more here or more here so you can preserve your retirement account.